Get a grip, then get a chip. Won't even trip. Though my cup was running over, I took only a sip. Stay hippin', then I'm hopping, I'm dropping. It won't be flopping, no shock. That whatever I'm selling, you will be copping. He was the strongest, though he was the one that cried. And he chose to kill his brother, cause he was from that side. And why? He chose this son, cause this one had pride. And instead of the narrow road, he chose the one that's why. Sometimes the one that won was the one that tried. And the one who pulled the gun was the one that died. Looking good, a good look is the one that's fine. If I had to pick, fly would be the one that's mine. G-O-D, in the place to be. Attendee, Hard Knocks University. And since kindergarten, they've been hiding the knowledge. Homeboy is self-taught, never went to college. I'm brown skinned, I'm from Pelon. Rainy alarm, then I remain cool and calm. Reading Psalm, fire like napalm bomb.
As we proceed to give you what you need, we are in the information age on Do You Know Your Value page. It's the content created with force like Darth Vader. Back on the track with the facts and all that. One path is the way that I'm taking, getting closer to God in a tight situation. Tonight we're going to be going over 12 presumptions. Yeah. So we're going to go over tonight, 12 presumptions. I promise to make it short, but sweet and packed with valuable information. And remember, take your time to do your own due diligence and look over everything that I mentioned in your own time. Do your own research. You're only going to be as good as your own research. Don't take nothing that I say for face value. Do your own research. There are 12 key presumptions asserted by the private bar guilds, which, if left unchallenged, stand as truth in commerce, which is one of the 10 commercial maxims. And the first one is the public record. The second one will be public service. The third will be a public oath. Fourth is immunity. Fifth is summons. Six is custody. 7 is court of guardians. 8 is court of trustees. 9 is government as executive / beneficiary. 10 is executive de tort, not a party to. 11 will be incompetence, and 12 will be guilt. I'm only going to discuss 6 of those 12 presumptions. However, Franco Collins did a superb job addressing these presumptions in an expose titled The History of Today's Slavery, and I encourage you all to read it. And by the way, this is a document. This comes from a document called How to Defeat Maritime Admiralty Law Courts. You go look this up on the internet on your own time. But this is what I'm reading from. I like to give you the references for what I'm reading. So it begins here. Well, it continues. Canon 3228.1, the presumption of public record. Any matter brought before a lower Roman court is a matter for the public record, when in fact it is presumed by the private bar guild as private business, unless this presumption is openly rebutted by filing or stating clearly on the public record that the matter is to be a part of the public record. The matter remains on the private side as private bar guild business under private guild rules. And that means the matter for the lawyers or bar attorneys. The defendant in this particular case recorded on the public record the registration certificate issued by the state of Florida, identifying his registered ownership of the fictitious all caps name, which proved that he was not the alleged defendant on the court's docket. I believe I should refer to him as the alleged defendant from here on. Canon 3228, number 2, 3, and 4, the presumptions of public service, oath, and immunity. If the judge ignores the alleged defendant's fictitious name registration entered into the public record, which is clearly presented to him in open court, and then decides to move forward with the case, he violates his public service oath and judicial immunity under these subsections. Canon 3228.5, the presumption of summons. A summons, when unrebutted, stands as truth in commerce. Attendance in a court is usually invoked by invitation, and therefore one who attends court, initiated by a summons, warrant, subpoena, or a plebeian bond, is presumed to accept the position of a defendant, juror, witness, or thing, and the jurisdiction of the court. If these instruments are not rejected and returned with a copy of the rejection filed clearly on the public record, jurisdiction, the presumed position and the presumption of guilt also stands as truth in commerce. In this particular case, the alleged defendant rebutted his false appearance by presenting the judge with the recorded registration certificate issued by Florida. This certificate stated he is not the defendant on the court's docket. The name is fictitious, and I am the registered owner of that name under Florida law. Canon 3228-6, the presumption of custody. Those who attend a court initiated pursuant to the command of a summons or warrant is presumed to be corporate property or a thing, and therefore is liable to be detained in custody by the court's appointed or elected custodian. Custodians may only retain custody over property and things, and not flesh and blood living beings. Unless this presumption is openly challenged by rejection of the summons or warrant on the public record, the presumption stands as truth in commerce, and you are therefore treated as a thing or property. In this particular case, this presumption was absolutely rebutted when the alleged defendant proved his arrest was a case of mistaken identity, and in no way could the court custodian detain him after that. I do not accept this offer of contract, and I do not consent to these proceedings. In addition to the above sections of Canon Law 3228, the defendant has also unknowingly rebutted the balance of the 12 presumptions: court guardians, court trustees, government as executor and beneficiary, executor de sun tort, not a party to, incompetence, and guilt. This particular defendant succeeded in accomplishing all of this by registering his all caps name as a fictitious entity in which only he now owns an absolute commercial and intellectual proprietary interest in the state of Florida. By entering it into the public record, he has overcome all 12 presumptions and nullified the prosecution and jurisdiction of the private Roman court. His next step will be to record it in the UCC, which is a notice to the world. Checkmate. There is no way for the corporate government and private Roman court to proceed against this living being. If the prosecutor was to disclose the presumptive frauds that the court has been operating under in the private side, it would also nullify the case and subject the judge to arrest and damages for prosecutorial fraud and the absence of jurisdiction. Please note that the judge's only legal response to the alleged defendant is to order a stay until the defendant secures counsel, meaning an attorney and bar guild member. If it is reported that the alleged defendant has not secured counsel, the case remains absolutely deadlocked. If this open stay does not cause him any harm, and it shouldn't, he can choose to do nothing, or he can file a 2-page motion to dismiss, or he can file a rule to show cause seeking a summary judgment for damages on behalf of his living being. What would happen if the individual follows the judge's advice and hires an attorney? In all probability, his attorney would use the alleged defendant's signed power of attorney to withdraw the fictitious name registration from the public record. The defendant would more than likely be imprisoned, tried on the private side, and convicted. What other applications can this process be used for? Licensing, tax collections, foreclosures, debt collections, the vehicle code, to name a few. Again, checkmate. Do you just love a good story with a happy ending? And once again, people, that's from a document called How to Defeat the Maritime Admiralty Law Courts. And I'm pretty sure you can find the document on the internet, just to give you a reference point of what I'm reading from. And you got to do your own research as well. You're only going to be as good as your own research. So keep that in mind. The definition of words is also a very important aspect of learning in general. You need to know what words mean. You also need to be able to read contracts. This is one of the ways where they keep the people subjected, where the servants keep you subjected, because the government officials are servants. They're all taking oaths to uphold the Constitution. So they are actually servants. They're not rulers. The people are the rulers. And like I said, you're only going to be as good as your own research. So make sure you're researching this information on your own. Don't take my word for it. Do your own research. Do your own research. Don't take my word for it. Be peaceful, stay blessed, and pray to pass God's test. And I'm going to talk to you good folks later.